everybody. Why don't we get started? We've got actually a very full and wonderful program here. Please feel free to continue to get food in the bag. But I wanted to get us started so we have enough time to hear from all of our terrific panelists here. So my name is David Wilkins. I'm the director of the Center on the Legal Profession. And I'm just absolutely delighted to welcome all of you to this very fascinating program on pro bono in Latin America. And we're very fortunate to have some of the world's leading experts on this issue, which has enormous implications, not just for Latin America, but really for much of the emerging powers in the world. And this is part of a larger project which we are doing as part of a project that some of you have heard me talk about before called Globalization, Lawyers and Emerging Economies, or GLE as we like to call it, in which we're looking at the development of the market for legal services in important emerging economies around the world. And one of the issues we're very focused on is the emergence of pro bono as a concept in many parts of the world, and what does that mean, and how is it developing? And we could not have a greater or better group of scholars to help us think about this issue. I'm going to introduce them very briefly in the order in which they will speak. We're going to start with Fabio Isai Silva, who is spending this year, we are very lucky to say, as a fellow in the Center on the Legal Profession. So for those of you who are really interested in this topic, Fabio is around all this calendar year, so this spring as well as in the fall. He is on loan to us from IPEA in Brazil, which, as many of you know, is the kind of the leading government think tank in Brazil. He has a PhD from Northeastern and done really path-breaking work on the topic of public interest law, and is really helping us to head up our efforts on thinking about global pro bono, particularly in Brazil. He will be followed by Daniel Bonilla, who's joining us from Colombia. Danielle has really written pioneering work on pro bono and public interest law in Latin America. He has a PhD from Yale, where his dissertation was on multiculturalism in Colombia and unattained promise. He may tell us the same thing about pro bono in Colombia, but we are really delighted to have him here with us today. Then Louise Trubeck. Louise, I think you're next, right? Louise Trubeck, who many of you know, has been doing path-breaking work on public interest law and pro bono and alternative forms of legal practice, multidisciplinary practice for low and moderate income individuals. She was a professor for many years at the University of Wisconsin, and now is kind of a roving global academic superstar going around the world thinking about these issues. And finally, if you read our poster, appearing remotely, as we say, is not the Wizard of Oz, but in fact the Wizard of Pro Bono, or the Wizard of Westwood. Yes, I like this metaphor a lot if you're a basketball fan. Scott Cummings is joining us from UCLA. He has written, really, in the U.S. context, the most important work on the institutionalization of pro bono. He has been leading our efforts in the GLE project around the spread of pro bono around the world, also is a leading expert on public interest law and on social movements generally. So, without further ado, I would ask Fabio to come up. I've been asked to be a rigorous timekeeper, so I think we'll get 20 minutes, Fabio, and I will be watching. All right,
okay, thank you, and I hope this will be doable. But so I want to thank David Wilkins and my fellow colleagues from the Center of the Legal Profession for both welcoming me this calendar year, but also for giving all of us who have been working in the GLE project the necessary support to conduct this important research. As he said, this is part of this broader project that is called Globalization, Lawyering and Emerging Economies. So we look at pro bono as just, one of the facets of in the growth of the corporate legal sector in emerging economies. And to do that, we kind of had two premises that came from the literature. One was that pro bono was something that we expected to see in these countries, Brazil, India, and China in particular, given its capacity to legitimize this new global economic order, of which the very growth of the corporate sector is part, in a way that it, on one hand, furthers corporate power, but on the other hand, appeals to some kind of corporate social responsibility. And on the other hand, pro bono could serve to legitimize also a globalizing structure of governance in which legal professionals have been increasingly empowered, which is part of the rule of law export trend that was revived in after the 90s, and we're glad to have Dave Turbeck here in the audience too, who has done work in this broader issue of law and development, and mapped this quite well. So, on one hand, we had these big forces pushing for pro bono to become institutionalized in these countries. These corporate firms would grow; they would look more like American or central countries law firms, and they would arguably incorporate this into their agenda. But on the other hand, we were seeing that this thing was not developing quite so fast and quite so well in countries like Brazil. So we sought to really explore this and try to explain what could be behind this. And I personally never had in mind that it would be just local and parochial interests, but it would be a more complex interplay, which in fact came to be the case. So, but precisely to do that kind of research, we looked at both the law firms themselves, interviewing firm partners, firm lawyers, pro bono managers, in-house lawyers who were trying to institutionalize pro bono in their departments, but also what we call the legal field more generally, including other legal actors in the country, the bar, the organized bar, in the case of Brazil, Ministério Público, Public Defender's Office, which are all very important in this landscape of public interest law. And other than that, we look at documents, previous studies, even did some observation when that was possible. And on the base of that, we got to 4 stories that reflect the different facets of this phenomena. The first of which I call Promoting Pro Bono, and it basically describes how pro bono first came to be talked about in Brazil, and that was a product of many converging interests. First, we had Brazilian lawyers with the U.S. training and socialization, and Oscar Vieira, the current dean of FGV, is a leading figure in this process. He comes to Columbia University, he does his LLM here, does work in law firms that have pro bono, get contact with people from the public council in Los Angeles, and then gets fascinated about this and brings these people to Brazil for a conference where he starts to spread this idea, right? Although he had some thoughts, had lots of thoughts previously about social responsibility of lawyers, because he was raised in the context of Brazil redemocratization and all that. But this model of pro bono he really gets from his exchange with the U.S. actors. Then there's corporate clients who need, they need legal help to undertake corporate social responsibility projects. So you have a bank in Brazil that wants to set up a foundation to give poor kids money to go to school. And this bank was a client of a big law firm, and all of a sudden it starts asking, we have, other than in addition to all of these that we get from you in terms of legal service, we would like to have your help to support this project. But I mean, you're not going to charge that, are you? And so it starts kind of a pressure to into law firms to develop this sense that they could be doing something for free if that was in the public good, because there wasn't a natural thing in the history of Brazilian law firms. And the firms themselves figure out that this could be good, to nurture professional idealism that young lawyers bring, as you all know, and also to retain these clients, right? So they start to think about pro bono. At the same time, there's a conflict with advocates for a publicly supported access to justice system, meaning public defenders' offices, who saw these as, sort of a privatization of legal assistance to the poor, and saw that as a risk or as a threat. And so what we have is these entrepreneurial figures like Oscar, who bring this US model, negotiate with needs of law firms, interacts with these advocates for this publicly supported system. And also build, and this is very important, they build on what they say it's a long-standing tradition in the Brazilian legal profession to help those who need. So they refer to people, like you talk about Brandeis here as the people's lawyers. They have these figures in the 18th century, who practiced law and who they see as doing pro bono, which is very different from what we see here now as pro bono. But they try to create this connection in order to make pro bono also something that has some indigenous rules. And that's the key thing here, right? It's not, they sell that not as an import, but as something that relates one can say closely or remotely to something that is indigenous. So in this story of promoting pro bono, I say that pro bono grows as this pastiche of corporate and professional responsibility in modern corporate firms, and this public spirit of traditional liberal lawyers. So then there is resistance against pro bono, right? That's the second story. And some of you know this, that the organized bar in Brazil was active in trying to prohibit pro bono. They saw that this was a sort of, this would foster sort of an unfair competition in the profession, because some lawyers would do pro bono exactly in order to secure clients. And so they characterize this as an ethical fault. So this is very, sounds very strange to US lawyers who have in their codes of professional responsibility, and I took classes here about this with David Hall at Northeastern, exactly to understand what was the mind of US lawyers. But, very interestingly, the bar characterized this as an ethical fault. And so they resist, they negotiate with law firms, and they come to an agreement in which these firms could not provide pro bono work unless it was to NGOs, so not individuals. And mostly what they would do was tax and transactional services for those NGOs to get set up and function minimally, right? And they create the pro bono movement create this Instituto Pro Bono that serves as a clearinghouse for these cases only, right? They aren't real cases, they're more day-to-day work in transactional law, right? And so that's how firms manage to negotiate some room for pro bono after getting this first push from, foreign and internal factors. And so this helps them to maintain some kind of pro bono practice, but to the extent that they had these fights against the bar, they had to make other alliances, right? So this is where the legal field becomes important, because they find support from other actors in the field, including public interest NGOs and public defenders. Now note that they were public defenders were against pro bono in the beginning. So why would they now support pro bono? Well, because the bar had the same issue with public defenders that it had with pro bono. It didn't want public defender offices to get structured, because they were trying to protect a market for legal service to the poor, who, even though being poor, would have some money to spend with some lawyers, right? Who wouldn't get better opportunities in the market. So it's interesting to see how these coalitions form and change over time. But the thing is, because of all those struggles, these public defenders and public interest law NGOs had a much more radical perspective towards legal assistance and legal mobilization than the original thinking of pro bono promoters, which was to simply deliver free services to individual, helping out to lessen the gap, of access to justice. So we start to see pro bono lawyers and the Instituto Pro Bono appearing, for example, as amici curiae in controversial cases before the Supreme Court, like affirmative action, for example, which is something that people wouldn't really think of pro bono when they first sought to institutionalize. Then there's an episode that there's something that's incidental here which is foreign law firms come to the country, and domestic law firms, again, the thing of coalitions. They have to partner with the bar to prohibit these foreign law firms to operate in Brazil, and then they kind of go backwards in their support of pro bono, and then the pro bono people, reach out again to corporate clients, all of that in the attempt to maintain the commitment of corporate law firms. Now what we have is, and I'm right on time as far as I can see. Yeah. So now what we have is the Supreme Court in Brazil struck down a law that gave the São Paulo bar some control over recruitment of lawyers to supplement public defenders. Remember that struggle between the bar and public defenders in order to protect the market. So the bar voluntarily canceled its prohibition to provision of pro bono to individuals, and it did so because it was fearing that this first Supreme Court decision could feed any further action to also remove this barrier to pro bono. And they're fearing that this would be struck down too. So we have now things these things are not clear. It's not clear how things are going to get settled again. So there's room for pro bono to grow in corporate law firms. But at the same time, with all these forces, we don't know whether these firms are going to incorporate pro bono, but also try to distance themselves from this more radical approach and do it in the more individual case-by-case basis. Or if, the Instituto Pro Bono will try to involve these firms in this more radical strand of legal mobilization. In the meantime, what we see is that some firms are, and that's the last story that I have to tell, rationalizing pro bono, meaning that they're trying to adopt internal protocols and tools of measurement and evaluation. So this could be something that would push towards a less radical approach. So, and this is also influenced by US forces, because we have some organizations here in PBI, which are going to their conference next month, is one of them, that have these packages for training pro bono managers and include this managerial perspective to pro bono within firms. So the questions we have now, and this is what I say, it's the crossroads of pro bono. And, it's pretty much what I've just said. Will the corporate law sector really embrace pro bono, or will it be established mostly in this province of civil society organizations and smaller firms and solo practitioners who actually do much more pro bono than the corporate firms now? If the corporate sector does embrace pro bono, how is it going to balance between this pulse for a more conventional and more radical, right? And how is it going to balance between this more systematic managerial perspective and this more, voluntary approach that's a mere response to pressures from corporate clients and other stakeholders? I think that sums up. It's a big paper. It's going to come up as a book chapter in one of our GLE books. And whoever has comments, like David said, I'll be around, would be happy to hear, in addition to what Luis and Scott and Danielle are going to say here, and all of you. Thank you so much.
Well, before starting my presentation, I would like to thank David for organizing this panel. It's really a pleasure for me to be here, and I'm very grateful for the invitation. It is great to be able to discuss these issues of common interest with Luis, with Fabio, and certainly with Scott. He disappeared. Remote. He's there. He's there. Oh, okay. So I would like to divide my presentation in 3 parts. In the first part, I would like to summarize the research project that I've been involved on pro bono work in Argentina, Chile, and Colombia. In the second part, I would like to present some of the weaknesses of the process of institutionalization of pro bono in these 3 countries. In the third part, I'm going to try to show some of the strengths of this process of consolidation. Now, the first part, the theoretical framework of this research project has 2 components. On the one hand, it's what I would like to call the political economy of legal knowledge. What we want to explore is how legal knowledge is created, how legal knowledge is exchanged, and how legal knowledge is legitimated, particularly in the context of the interaction between the legal academia of the global north and the legal academia of the global south. Of course, the implicit premise here is that pro bono is a legal transplant, and we want to explore how this transplant arrived to Latin America and how this transplant has been translated to within these local contexts. The other component of the theoretical framework that nourishes this research project is the idea of the social responsibilities of lawyers in democracies in process of consolidation. So the question here is, if lawyers in countries like Colombia, Brazil, Argentina, Chile, have social responsibilities that are different from the ones that lawyers have in consolidated democracies like the US or many of the countries in Western Europe. Now, in order to put in operation this research project, we got together with several academic and social organizations. So the partners in this research project were, on the one hand, Universidad de los Andes, where I work. On the other hand, the Pro Bono foundations of Chile, Argentina, and Colombia. They are located in the capitals, Bogotá, Buenos Aires, and Santiago. And in the case of the field work that we did in Bogotá, Forum, particularly Forum Law School, was also a partner. Now, the aims of this research project were mainly descriptive and analytical. So what we have been doing is to try to describe and to understand the dynamics of pro bono work in these three countries. In that sense, the time framework of our work is since the creation of each pro bono foundation in these three countries until 2014. Because we believe that the creation of these pro bono foundations has been key for the institutionalization of legal pro bono in Argentina, Chile, and Colombia. Now, the methodology that we used to gather the empirical information that we needed to understand the dynamics of Bono in these three countries was a combination of semi-structured interviews. We conducted around 190 interviews in these three countries, and 2 online surveys that we sent to the 3 foundations and to all the law firms that belong formally to these foundations. So the research project has various dimensions. But as I said before, I would like to focus on one specific issue that is key, I believe, to understand the dynamics of pro bono in these 3 Latin American countries. And that is the process of institutionalization, right? So how, do lawyers in Bogotá, Buenos Aires, and Santiago started to think about pro bono? And how did they start to create structures within their law firms in order to do pro bono in an appropriate way? Now, what are the strengths of this process of institutionalization of pro bono in Argentina, Chile, and Colombia? I would say that the most important element here was the creation of the Pro Bono Foundation of Santiago, the Pro Bono Foundation of Bogotá, and the Pro Bono Foundation of Buenos Aires. These 3 institutions were key for the creation, of a still incipient movement of pro bono, of legal pro bono in these 3 countries. And the influence of the pro bono foundations can be seen in the following areas. On the one hand, on the concept of pro bono, and how law firms and lawyers that belong formally to these 3 foundations have a homogeneous understanding of what pro bono is. And I think this is particularly important because before the creation of these foundations, of course, many lawyers did pro bono, but they didn't think about this kind of work as pro bono. They didn't use the category, and they didn't have a narrative, a specific discourse, theoretical and practical, to think about their practices. With the arrival of these 3 foundations, this changed. And it is notable to read the interviews in these 3 countries. There's 190 interviews in these 3 countries, and find that there is a wide agreement on what pro bono means, right? And it's a standard definition of pro bono. It's nothing extraordinary. But what is extraordinary is the homogenization of, let's call it the legal and political imagination, the component of our legal and political imagination that is connected to pro bono and that is connected to the social responsibilities of lawyers. Now, it is also interesting to note that lawyers in these 3 Latin American countries believe that pro bono is a voluntary and subsidiary duty. So the primary duty for promoting access to justice and for promoting the public interest is, from the point of view of lawyers in the state. The state has to know this a specific role to play. And also that they do believe that pro bono shouldn't be imposed. It shouldn't be imposed by the state and shouldn't be imposed by the law firms, right? Again, it should be a voluntary and subsidiary work. And the key components, as I said before, this basic concept, the homogeneous concept of pro bono is that it's the free legal services that law firms provide to low-income individuals or to NGOs that serve these low-income individuals, or the legal activities, free legal activities provided by these firms to advance the public interest. It is also interesting to note the relative homogeneity of the arguments that support, that justify pro bono in these three countries. There are domestic variations, but it is interesting to find that there are three main arguments supporting pro bono from a theoretical perspective for most lawyers in these three countries. On the one hand, the principle of equality. On the other hand, the right to access to justice. And finally, the principle of solidarity. Now, in Chile, it is interesting to note how religion plays an important role in supporting, in justifying pro bono. No? So the reference to Christian charity appears continuously in the discourse of lawyers doing pro bono. While in Argentina, the emphasis is on giving back to society, in as much as most lawyers graduated from public universities, particularly from Universidad de Buenos Aires, UBA. So they feel that they have a duty to give back to society because they were able to study for free, because of this great public university. In Colombia, things are a little bit more more complex in the sense that there's no one clear argument accepted by most lawyers doing pro bono that justify the work that they do. It is also interesting to see how, because of the influence of the pro bono foundations, the law firms that work with them, for them in part, have the same structure, the same organizational structure for doing pro bono. So they have a pro bono partner, they have a pro bono committee, and they have a pro bono coordinator. And finally, for institutionalizing pro bono in these three countries, it has been key the clearinghouse role played by these three foundations. So truly they have been mediating between the offer and demand of legal services in the country. And this is truly important because the foundations create a bridge between law firms and low-income individuals. Now, the work that has been done by these three foundations that has promoted the institutionalization of pro bono in Argentina, Chile, and Colombia has been strongly influenced by the US, in particular by New York law firms and by the Van Center. So in this sense, pro bono is a legal transplant. And there's nothing wrong with that. No, I don't think that legal transplants are problematic per se. I think that in many cases have been the engine of legal change all over the world and for several centuries. What I think is important to do is to understand the specificities of this legal transplant, how it was transferred, how this legal knowledge was transferred, and how, if in any way, it has been transformed in local contexts. Now, where do you see the influence of New York law firms and the Van Center? I think that you see it in two key areas. On the one hand is in the drafting of the Pro Bono Declaration of the Americas. And this declaration has been instrumental for the institutionalization of pro bono work in Latin America, and in particular in these 3 countries. Also, the Vance Center, and in some cases in partnership with big law firms in New York, have organized seminars, conferences, and published a series of documents about pro bono that have been used widely by these foundations and by the law firms that belong to these foundations. So if you see, for example, the institutional structure that I mentioned before that allows for these law firms to do pro bono work, you'll find that these structures are reproduction of what the Vance Center recommends that law firms should do if they want to do pro bono appropriately. The same happens with the concept of pro bono, right? You find important parallels between the concept of pro bono that I mentioned before, that is widely accepted by lawyers belonging to the foundations that I mentioned before, and the definition of the Pro Bono Declaration of the Americas. Now, I think that it is also important to note that although there have been efforts for translating and transforming the legal transplant, I think that the process is still incipient. The influence of the US pro bono concept and the US pro bono practice is still very strong. I think that this is going to change, and you can see certain areas where this is changing. For example, in the role of solo practitioners in pro bono. No, that is different from the process of institutionalization of pro bono in the US. You can see that in the work of Louise and Scott. Now, why this legal transplant? Why law firms and the pro bono foundations of these 3 countries have imported pro bono, and why the Vance Center and US law firms have been trying to export pro bono? I think that there are different explanatory reasons that can allow us to understand this process. On the one hand, certainly there are some principled reasons. Many of these lawyers do believe that there is a moral duty to do pro bono work. And of course, the specific principled reasons vary, but no, there is a principled justification of pro bono work. Now, there are also strategic reasons that explain why pro bono has been transferred and has been transferred by the US and received by many Latin American countries. On the one hand, what we can call the globalization of the legal market. So for more and more US law firms, the Latin American legal market is attractive. In countries like Brazil, Argentina, Chile, there are a lot of important opportunities. There's money, right? So through pro bono, they're able to meet new law firms, to work closely with law firms, and to be able to think not only in pro bono, but in work that is paid by big corporations, both national and domestic, and multinational or international. The other important issue is reputation, right? In particular for Latin American law firms to be able to be connected, to be linked to big US law firms, particularly in Washington, New York, is very important, right? From a corporative perspective, but also from a personal perspective. So it's interesting to see, and this is purely anecdotal, but I think illustrates well the issue, how when partners from US law firms and the directors of the Vance Center go to Bogota or to Buenos Aires or to Santiago, all the partners go to the meetings about pro bono. They all get there, and they know the photographs are great, and the promotion of this meeting is great. After the New York people leave, the partners, the local partners, disappear, right? So reputation is important, and nevertheless, right? Still they have to be at least a little bit coherent. So some of these partners do promote pro bono within their law firms. And in the case of the US, some of these big US law firms do this kind of international pro bono work because they think that that these hours that they do in Latin America or in other parts of the world count as part of the minimum hours that they do have to work on pro bono. Right? So they go to Colombia and say, well, we did 20, and they add it to the list of hours that the law firm has worked on this area. So there are some interesting issues here, that show how this institutionalization of pro bono has been done in these 3 Latin American countries. However, I think that there are some important weaknesses, and that the process of institutionalization is still incipient and incomplete. And since I have only a couple of minutes, I'm just going to mention them to enunciate them, and perhaps if you want afterwards in the Q&A section, I can elaborate on them. So the first weakness is related to the concept of pro bono. So in Argentina, both the foundation and the law firms that belong to this foundation believe that what they do when they do pro bono is what they call structural pro bono. So in a conscious way, what they have been trying to do is to distance themselves from what we can call access to justice pro bono. Because they believe that they want to distinguish themselves from the traditional bar, and they think that the human resources that they have can be better used in working on structural issues. However, when you hear what they do, it is very difficult to call it structural pro bono, because mainly what they do is to work with NGOs, and from a corporate perspective. So they incorporate these NGOs, and many of these NGOs are NGOs that have links or were created by their corporate clients, the clients that pay for the work that they do. So it's questionable, I believe, that in Argentina they are truly doing structural pro bono. In the case of Colombia and Chile, they consciously have opted for access to justice pro bono. However, the weakness there is the small number of cases. So the impact of what they have been doing is not notable. However, it is important, right? And what illustrates the incomplete institutionalization of pro bono is that very, very few law firms in these 3 countries comply with the only mandate with the only obligation of the Declaration of the Pro Bono Declaration of the Americas, and that is 20 hours per year per lawyer. Not much, right? It's like 2 days of work of any lawyer, right? Now, just other issues to round up my presentation. With regard to the pro bono structures and practices within law firms, there's no reliable information about what they do on pro bono matters. There is no strong commitment of partners to pro bono, and this is particularly important in a setting that is very hierarchical. If the leaders of the institution do not make clear that they are committed to doing pro bono, nothing is going to happen. There are no real incentives for doing pro bono work, and the most important example of this is that in the great majority of law firms, pro bono hours are not identifiable with billable hours. There are no clear internal policies about pro bono. There's no budget for pro bono work in the overwhelming majority of law firms in Argentina, Chile, and Colombia. There is attention thinking now not on issues related to the structure of each firm, but thinking about the relationship between clients and law firms. There are serious problems of communications between these elite lawyers and the low-income population that they serve. In many cases, they don't know how to speak to each other. They don't understand themselves. Also interesting, and this is something to explore from a gender perspective, there is some kind of feminization of pro bono. So the great majority of pro bono coordinators are women, young women, junior associates, right? And this is important from a political perspective because, well, they have no political power, right? And this means that pro bono doesn't have political power within the law firms. And finally, thinking about the relationship between foundations, the three foundations, and law firms, we find that these foundations are politically weak. And they're weak because they have no autonomy, because they have very few human and economic resources, and therefore their political leverage vis-a-vis the law firms is not very big. Thank you very much.
Okay. I wanted to put these two presentations a little bit in the context of the broader spread of pro bono throughout the world. Global pro bono is about spreading the U.S. model throughout the world. And I wanted to talk about two aspects which strike me as being helpful in thinking about that. The first is the role of corporate social responsibility. And a second is a little look at the development of pro bono in Europe, which is an emerging field. First, on corporate social responsibility, both Danielle and Fabio talked about how the corporations were using the lawyers to help advance their own projects, such as the bank in Fabio's case that wants to set up this organization for kids. And Danielle talked about the importance of the corporations using the lawyers to help do their foundations. But that we have to understand in the context of corporate social responsibility. In the United States, pro bono has not been related strongly to corporate social responsibility. When you look at pro bono at the rest of the world, that's an important factor, and that really gives us a different way of perhaps analyzing it. In the 2000, there was the Ruggie, beginning in the middle 2000s with the Ruggie UN Guiding Principle of Business and Human Rights. And this has been very influential with the corporations throughout the world. And this is beginning to influence the lawyers. And the intersection between the two has become quite a driver for the development of pro bono in the rest of the world. And as Fabio pointed out, the International Bar Association has just opened a global public consultation on its draft business and human rights guidance. And when you read it, it's basically the IBA is trying to move corporate social responsibility into the corporate law firms and saying, how can we work together on this and make this an important element? And they're bringing all the various stakeholders in. And so this is a follow-up or building on the Ruggie UN principles. And so this is to Americans, it's striking how this is something that we have not associated at all with pro bono. And so therefore, some of the ways in which it's developing in the rest of the world have to be seen through that context. That is, the clients are driving it. These big corporate clients who are, after all, as you're moving into a global economy, and in the emerging economies in particular, that is a very big driver. And I think one of the things to think about, the difference between Brazil and what's going on there in pro bono, the complexity of it, and the Argentina, Chile, and Colombia, is that Brazil is a large emerging global economy now. The other Latin American countries are less so. And so when I went to Colombia and talked with down there, Danielle did a great program down there, I thought that was, they don't have the presence of these global law firms in the corporate law firms in the same way. And that, I think, is something to think about as we look at pro bono in the rest of the world. My second comment is on pro bono in Europe. I recently was in Europe, in Florence, at a program that was put on to explore lawyering for social justice in the U.S. and Europe. And it's just amazing what's happened in the last 10 years. There has been this really growth isn't the right word, the branding of public interest lawyering in Europe. And here we're talking about Europe, the European institutions primarily, rather than the member states. And they're, generally speaking, Western Europe in particular, had very distinctive ways of doing public interest, and was not sort of an outlier, you might call it. But in recent years, it's been a tremendous growth, and they link it together in three ways: public interest lawyering, which includes strategic litigation; clinical legal education, which was almost not there; and pro bono. And they see it as, some people see it as linked. And PillNet, which is New York based, but been very influential, like the Vance Center, but throughout the world, they work on all three together. And they started, of course, in Eastern Europe. So one of the drivers in Europe has been the collapse of the Soviet Union and the development of Eastern Europe. And there they were much more receptive to the model of clinical legal education and public interest lawyering. So there's been a little bit of a spread from Eastern Europe towards Western Europe, and of course many of them are together in the European Union. So one of the how do we understand this development? And one of the interesting parts of it, when I talk with the European students at this conference I was at, of this teaching I was at, was that, of course, in Western Europe, you have very well-developed legal aid systems, public legal aid systems in many of the countries, and there's an effort to develop them in Eastern Europe as well. So you have this question of what is the interaction going to be, pro bono, clinical education, public interest law, on the legal aid systems and the public systems there. And the other, and what's come up, just to circle back, is there's an interest now in the legal transplantation. One of the things that the students were interested in, both advocacy for these kinds of programs, but also to develop a sociology and legal studies of the development of public interest law. And so they immediately, these are PhD students, very interested in the legal transplantation issue, and whether, because many of them view it as US-led and US-funded and US-inspired, even though there is a large tradition of indigenous work within those countries. So it's a very interesting, new, and sort of unexpected contributor to pro bono throughout the world to see what's happening in Europe.
Thank you. He appears. Oh, great Oz. Scott. Big brother.
I'm going to sit on the other side.
Thank you, guys. Can you hear me okay?
Yeah, I think so. Go ahead.
Okay, good. As always, it's wonderful to see you all, even though it's through my computer screen, and you guys are all a little blurrier than I remember you. But I can genuinely say that I wish I were there for the warmth of all your company, but I would be less than candid if I were to say that I wish I were physically there in your frozen city, particularly as I gaze out of my window at another sunny LA day. But I do want to thank you all for giving me the opportunity to weigh in here from this place of warmth. And I just wanted to take a few minutes to offer some thoughts on what I thought was a tremendous panel. And as someone who's observed pro bono for more than a decade now, I wanted just to start by saying that I've been thrilled to see both the development of pro bono as a field of practice, but also to witness its growing strength as a field of academic inquiry. And I wanted to begin by just marking the incredible work of both Daniel Bonilla and Fabio de Sea Silva for their empirical sophistication and their analytical depth. And I think it's safe to say that their work is now really setting the intellectual standard for all of us who care about pro bono in its relation to broader shifts in the profession and politics. For me, each of their talks really raised what I think of as the three fundamental comparative questions about pro bono's global development. The first I like to think of as the why. So why is all this happening? What are the different mechanisms of change across context? How do professional or social norms of giving back get mobilized to support different concepts of pro bono? Is it globally driven? Is it local? Is it through global corporate clients or indigenous professional actors? Is it about the decline of the public sector, as Louise just mentioned, or the rise of the corporate bar, et cetera? The second question I think of as the what question. So what does pro bono look like in different contexts? What is it about? Is it access to justice, maybe Colombia, Chile? Public interest law, maybe the Argentina story? Corporate social responsibility, maybe Brazil? A combination or something else altogether? The third question I think of is the sort of so what question. And this, I think, goes to assessment, both empirical and normative. So what should we think about pro bono's evolving professional role around the world, both in specific national context and as a global phenomenon? Is it good? Is it bad? Under what criteria? Does it displace or strengthen legal aid? Fabio, I think, described pro bono in terms of political contests among different professional and political actors. And I think it's interesting to think of who wins and who loses in all of these contexts. The US experience is an important point of departure, not really because it's a model, but because it was an important, it was in an important sense, I think, the first in terms of achieving a deeply institutionalized pro bono culture. And also, I think as both stories today show, the US remains, for better or for worse, a really centrally important global actor in spreading pro bono. With respect to the comparative point, I want to come back at the end with a brief response to Fabio's provocative idea, which comes out in his paper, though I wasn't really able to hear well enough to know if he discussed it in his talk. But the idea that Brazil may be a counterexample to the US and sort of generally to the question of how similar or different these experiences are, and if this is even the right question to be asking. But just let me emphasize a few brief points here. First, in the US, the growth of pro bono has clearly been linked to the decline of state-sponsored legal services, with the organized bar championing pro bono as an alternative to the beleaguered federal system, and the conservative movement sort of positioning pro bono as less capable of being captured by liberal cause lawyering. Second, although pro bono is spread throughout different sectors of the bar as a professional ideal, it has been really tethered to the growth of the large law firm, which in its explosive growth over the last 25 years has really adopted pro bono as a central expression of professional virtue, while also using it to recruit and retain attorneys. Third, there's been a push from corporate clientele and an assimilation of pro bono, I think gradually, and this goes to Louise's point, into the framework of corporate social responsibility, I think along with things like law firm diversity and charitable giving. But one thing that distinguishes the US experience is that pro bono started as professionalism here and has only subsequently been integrated into the CSR framework, which seems to be in contrast with some of the other stories we heard today and has linked pro bono, I think, more to anti-poverty and public interest law domestically here. Finally, what in my view really changed the game in the US and produced the deep institutionalization of pro bono over the past 20 years was the advent of law firm rankings in the American Lawyer magazine. And that system, which ranked the biggest firms by revenue on the basis of pro bono performance, led to a competition for pro bono now as a positional good, because firms wanted to score high in order to attract the best and the brightest. And the creation of the system and its emphasis on counting hours as the metric of success has produced among the most elite firms, the top 100 in particular, investment in personnel with the growth of pro bono counsel positions and an increase in average hours per lawyers that has been empirically documented in many places. And so as a result, pro bono has become deeply embedded in the culture of big US firms whose lawyers have promoted its value throughout the profession. In contrast to this story, Daniel Bonilla tells us a story of incomplete institutionalization in Argentina, Chile, and Colombia. And I think Fabio talks of Brazil as a counter-hegemonic example, a counter-example to the US, with corporate firms moving away from pro bono to close ranks with bar leaders against the common threat of market liberalization. And so I wanted to end by just thinking a little bit about what explains the differences. And this is not a question I can answer, it's really for the area experts and for all of you. But let me just highlight what struck me from the presentations and from the written work as important factors that shape institutionalization and lead us toward more of a comparative framework. So first, again, the role of measurement and enforcement mechanisms. I've suggested that in the US, connecting the measurement of pro bono hours to the status ranking of big firms has been really critical in pro bono's growth. Argentina, Chile, Colombia, Daniel says, a lot looks the same as the US story. Pro bono has been linked to law firms' self-interest and reputation, and the bar has come in to promote compliance with domestic pro bono rules. But the Declaration of the Americas, which is a sort of voluntary analog to our law firm pro bono challenge, hasn't produced the sort of deeply embedded pro bono at the law firm level, in part because less turns on non-compliance. So there may be a shaming factor involved in low performance, but it isn't linked to status in the same way as the American lawyer does here in the US, and that perhaps makes it only a weak inducement. Now, there are lots of distortions that the US ranking system produces, but one thing it does seem to do really well is increase pro bono quantity. This connects to the second point or factor, which is the sort of respective roles of external incentives versus internal firm-specific incentives to do pro bono. So how much does internal organization matter? Again, Danielle says junior lawyers want pro bono, but they're weak internal incentives, few policies and procedures to support them, as I heard it. Again, using the US as a comparison, it may be that internal law firm policy development only happens in a robust way if there are strong external incentives to force firms to make it easier for junior lawyers to access it internally. A third factor I wanted to highlight, now connecting, I think, more essentially to Fabio's story, is the sort of role of open versus closed legal markets. If markets are open or opening to foreign law firms, there are more pathways, obviously, for pro bono to enter, either carried by global law firms or adopted by local firms in order to compete with their foreign counterparts. This creates the possibility of more pro bono inducing alliances, I think. Closed markets and resistance to opening produces different types of alliances, like the elite local alliance against foreign entry in Brazil, undercutting support for pro bono and then pitting the private bar against the public sector bar, comprised of NGOs and public defenders. This open-closed dimension, I think, relates to the position of global corporate clients versus global law firms in the development of global pro bono. So corporate clients have different interests, ultimately, than global law firms. Both want entry to local markets. We would expect global law firms to directly bring in norms of pro bono, but when they're blocked, global companies are still willing to work with local lawyers, and in so doing may import CSR, as Louise was suggesting, rather than pro bono. So in closed legal markets, without a strong foundation for local lawyers to adopt pro bono, we might expect to see pro bono framed more centrally around CSR norms, which seems to be what Fabio has found in Brazil. And this may help explain another phenomenon, which is US firms, which I think, again, Louise and Danielle both alluded to, sort of using CSR pro bono projects as a wedge to enter into markets in emerging economies. Another factor, and this is toward the end of the list, alluded to already, is the respective positions of private versus NGO and or government lawyers relative to pro bono. So where there's a strong linkage between the corporate law sector and pro bono, when pro bono sort of comes out of corporate law, there may be more hostility from the NGO and state sector, which may perceive it as undercutting its position. Maybe this is part of the early US story. But when pro bono comes more out of the public interest legal aid field, sort of moved along by global elites, maybe as in Brazil, and pro bono and public interest law advocates may create an alliance to pressure the recalcitrant private sector to do more. This leads to the final factor, which is the respective roles of an interaction between the sort of local and global elites and their relation in turn to non-elite indigenous lawyers. Fabio discusses the role of globally circulating lawyers. Brazilian lawyers go to the US and learn about pro bono, bring it back, gain professional standing by bridging with U.S. elites. It's important to emphasize that U.S. lawyers gain something in this transaction as well, which I think Daniel has written quite powerfully about in other contexts. And if you'll indulge just a final anecdote in this regard, I mentioned at the beginning that I had my own role as an actor in this unfolding pro bono story. I was an attorney at the Los Angeles organization Public Counsel in the late 1990s that Fabio mentions as central in the Brazil story, when my boss, Dan Grunfeld, went down to Brazil to help promote the Pro Bono Institute. And it was at that moment of career transitions for both of us. And I can say, looking back, that part of Grunfeld's interest was connected to his own thoughts about what to do next in his career and how he might transition into a global pro bono promoter role. He also encouraged me to write about pro bono as I was thinking about pivoting into legal academia. And it was really through discussions with him, in part about his work in Brazil, that I began thinking of pro bono as a field and really charting my own academic contribution to the discussion. So there's a sort of important professional capital story that really runs in both directions in really interesting ways. I'll end by just responding and maybe pushing back a bit on Fabio's claim, again, which comes out in his paper, but I'm not sure as much in the talk, of Brazil as sort of a counter-hegemonic story, that Brazil is sort of different in kind than the US. I think another possible way to look at it is that the corporate law sector's interests are central to the development of pro bono across the global North and South, and it's precisely whether and how those interests align with pro bono that may be the decisive factor influencing its growth. So US corporate law sector embraces pro bono as central to its identity and self-interest. In Brazil, the forces are quite different, pushing corporate law away from pro bono, but corporate law self-interest is still quite decisive. So thank you. With that, I'll stop. I'm eager to hear the subsequent conversation, and thank you again for having me.
So I think we have time for questions if people are able to stay. So just raise your hands. Yeah, please.
I have a question for Professor Bonilla and Professor Reza. I'm from Latin America, from Chile, and I think that in Latin America we still are facing like great challenges with respect to access to justice. So my question is, do you think we are prepared to rely solely or exclusively in a pure voluntary model as it's pro bono, or we should continue combining pro bono with more like mandatory requirements to attorneys in order to work for the full, like certain hours in order to remain in the bar, or more like mandatory kind of mechanisms?
So the first, I mean, I think both questions are quite normative, but first, I think I'm a pluralistic person. You know, I think the more you have people, and this is what I am critical about what happened in Brazil, in which at some point we thought, and I was in the student, when I mentioned here that the public defenders were against the pro bono movement in its early days, I was lined up with the public defenders as a student leader. You know, we were very critical to pro bono because we thought it would lead to privatization. But I became critical after that to a structure of access to justice that rely only on the state. I think civil society has to have, you know, its own mechanisms, and public interest NGOs, you know, must have a role to play in this conversation. And obviously, I mean, the private part can do its own things too. And corporate lawyers could do, or you know, smaller law firms. Scott talks about the private public interest law firms. He has a paper on this specific model law firm that exists in the U.S. I mean, I'm for any, you know, and the more kinds of enterprise we have with that characteristic, I'm for. and I don't think at all we should, try to rely neither solely on public sector nor solely on the bar. And the second question is, would would it be good to have mandatory pro bono? I think the discussion itself has a merit in it because it forces the local bars in Latin America to reflect about the role of professionals. Because one thing that's clear, at least in Brazil, is how powerful these organized bars are in terms of being able to secure privileges to lawyers, but how weak they are in terms of really reflecting about norms of professional conduct or reflect and enforce norms of professional conduct and of this public good facet of lawyering. So I think this discussion adds a lot into the domestic context.
I agree with Fabio. What I would add is that the problems that we have in Latin America with access to justice, with the lack of realization of this fundamental right, are structural problems. So we should attack this problem from different perspectives, both public and private. I think that one area where many Latin American countries should work on is on the expansion and consolidation of public defenders' offices. I think that the state has a very important role to play here, right? And again, since the problem is structural, right, the muscle of the state should be put into operation in order to protect this fundamental right. However, I would say that not only law firms and the bar have a role to play, because lawyers do have social responsibilities, particularly in these democracies that are in process of consolidation. I would say that there are other actors, legal actors, that also have to play a role in the realization of the right to access to justice. And one that is very important is law schools and law students, right? So we have seen it in Chile, in Colombia, and Argentina, but I think that legal clinics have been in crisis for a while in our countries, precisely because although they were thought as an anti-formalist tool, they were co-opted by legal formalism. So there are not spaces for creation, innovation, for thinking in law as a tool for social justice, but a space that, in the best of cases, and this is not very often, they allow students to develop certain skills that are useful for practice, but not more than that. The social justice aspect, is sent to the margins.
Yeah.
Want to take 2 or 3 questions?
I have a comment on three of these things, and I would be very interested in your reaction to it. I've spent a lot of time working on making access to law more available. And I think one thing that has happened with pro bono since it became institutionalized is the face of pro bono became the big corporate firm. And that happened sometime in the 80s, and I think it is connected to the continued attack on government-funded legal services, and it peaked again when Reagan was elected in the 80s, and those lawyers turned in other directions to get support. What saved legal services, I think, decade after decade in the United States is the American Bar Association's strong backing for it. And the ABA began instituting pro bono. And that produced something that I wonder if you are seeing or have seen. You commented on it. There is tension between corporate law and small law in the United States. Before pro bono was institutionalized, it was mainly done by solo and small firm practitioners, informally at the local level with a mix of altruism and business gain. I will help the wife deserted because the business that I represent the small business I represent, they need the help. Not collecting on fees that were, you entered into a fee agreement, a payment was made, the client couldn't pay, and the lawyer says, I'm gonna finish this for you. When the ABA passed its, the language in the code says that it's only pro bono if you took the case without expectation of a fee, that really pissed off the solo and small firm bar. And there continues to be a tension between these two faces of the bar, between the solo small firm who see themselves as doing this, always being the engine of pro bono, and suddenly the big firm's getting all the credit. So that's one thing. The second is, what do we get out of pro bono? Is it efficient? So the idea of 20 hours a year after year, what can you do in 20 hours? What do? At the end, you stop. If you spend 60 hours 1 year, should you not have to do it the next 2 years? So the idea of a modest contribution, and then what if you were going to institutionalize and make it formal, how the hell would you manage? Excuse me. Why would you manage? Then what do we get out of it? What's the result? Is it worth it? Because most pro bono is not free. It requires some, usually public investment to institutionalize not only the matching, but the training of the corporate lawyer, at least to be able to do small law things. When they're doing the kind of the kind of work they usually do, big time litigation, then it's fine. They know how to do that. But there's competition among the legal services elites, the big names in legal services. They don't want to give up those cases. Those are the prizes that they do. So they don't want to compete with big firms to take the major headline-getting cases. And the last thing is clinics. In the States, this has not been commented on much. Pro bono and clinics are conjoined at schools like this. We had a clinical program before we had a pro bono program. It had a strong notion of adding educational necessity, things that were needed that American legal education didn't address, partly because apprenticeship died out in the United States. Most of your countries do not have bar access that's like the United States, which is 3 years. You can take 3 years of classroom-based education, be admitted to a bar, never see a client, never serve, never get any training, and you can hang out a shingle. That's not true in other countries. So what you get is pro bono is combined with clinics, and then clinics become an avenue of public service in elite schools. And those are the ones that have pro bono graduation requirements. Down the hierarchy of the education, pro bono is not required. Graduates are just desperate to get a job. And so pro bono is all career oriented, and needs to serve, if it serves anything, an apprentice-like function. So, because we've overpopulated law schools. We've got too many students for the available jobs in the States. And the students who graduate from law school can't do anything. So unless they go to work for someone who can train them, they're out in the cold. So you've got this also division and tension within law schools, all within a larger professional vision that asks the unending question about the United States: do we have one bar or two or three? Sometimes we want to think we're one bar, and then other times you see the tensions. And I guess what I'm saying is, pro bono in the United States, I don't think is well understood, and we're exporting it. And I think I hear you as beginning to see some of the tensions that are here that we barely acknowledge in the United States. So in a way, I'm saying, be careful.
So let's there's obviously a lot here, but what I'd like to do is collect a couple of other questions and then have our panelists kind of pick what they would like to respond to. So here, and then Dave, and then did I see anybody else's hand up? You had your hand up, right? Yeah, please. Go ahead.
I think I should thank her so much. She's really like absorbed most of it.
Well, Jean is amazing.
Particularly the tension between big, small organizations, and is particularly significant, like between the North-South organizational collaborations, where you have organizations probably from the North supporting organizations who follow the services, organizations working in the South. And when it comes to acknowledgement of efforts, it is so uneven and unequal because the other has so much power to amplify what they do, and what they amplify is sometimes it drowns the effort of the other organization on the ground. So I see that the work inequality is huge. It's so huge. It's like I can't even describe how huge it is, and it creates a lot of tension, and it makes smaller organizations, sometimes imperfect. Secondly, the other issue is that it is actually possible to make pro bono services more attractive and more financially rewarding in terms of the kind of investment that goes into it is also equally intense. But you find out that people that work in small organizations providing pro bono services sometimes earn so little compared to their corporate lawyer counterparts in other organizations, sometimes who do a lot less. Is it possible to also make, match the intellectual investment that goes into pro bono services, match it with the kind of output or the reward or remuneration or compensation that goes with it? Thank you.
Thank you. And then Dave? Oh, I just,
Students, I'll defer, but
I did, anybody else? And then I'm just gonna give each panelist an opportunity.
there-
Yes,
there's
please.
another.
I was wondering if in the study there were any persons that talked about what you do not pro bono.
Thank you. And then Dave, and then we'll give each of the panelists a chance to kind of pick some of those things, but I'm glad my favorite student from Argentina said something. Go ahead, Dave.
So there was once in the history of anatomy, I believe a soldier had his stomach blown away by a cannonball, but he kept functioning. And because of this, they were able to study the operation of and they learned a lot about anatomy. And this, for the people who are interested in the legal profession, this topic is the same thing.
Yeah, I agree.
Because if you look at this topic, many of the really fascinating questions about legal professions in our time are present. So the tension between a business and a profession, and whether doing good is a business move or a moral and ethical act. The tension between the global and the local. This is a global phenomenon, but it's encountering local complexities and taking on wonderful and fascinating hybrid elements. The tension between a hegemonic global legal profession controlled by and dominated by America versus a multi-plural global legal profession, if it is global. And then the question of activity of this type, is it effective to change the world in some real way, or is it just symbolic politics to make lawyers feel better or look better? All of those questions can be looked at in opening up this particular piece of the legal profession. We could just, make a whole career out of it.
I agree.
And some may do that.
Yes. Well, speaking of some that have done that, why don't we give each of our panelists an opportunity to respond. So Fabio, I'm
Want
sorry.
to go backwards and have Scott?
Yeah, why don't we go Scott first, since he
Okay.
has he just acknowledged he has made a whole career out of it. So,
So I'm going to respond in a little bit of a sporadic nature because I couldn't quite hear everything. And I think I heard Jean's comments the most, all of which I agree with completely. And I just wanted to maybe add a few things to them. So on the point of sort of small versus big pro bono and some unfairness embedded into the definitions, I think that's right. And I'd add a couple of other points to that. One is there's the idea of pro bono being without expectation of a fee. Some big firms may not have expectation of a fee in taking on sort of big fee shifting cases, but ultimately end up getting fees. A lot of them donate them back to the nonprofit sector, but not all of them do. And so the line of do you expect or not is very blurry, and as a sort of foundation for distinguishing pro bono does seem to be very problematic, to say nothing of the other sort of ancillary economic benefits that law firms may derive from pro bono. On the question of evaluation, I think, again, this is what I heard from Jean, very correctly identifies some of the efficiency transaction costs in the system. There's also other kinds of assessment questions like, is the pro bono system solving the right kinds of legal problems? Is it investing in responding to the social need as opposed to, or in addition to, responding to the interests and needs of its lawyers? And then on this interesting point about the conjunction of pro bono and clinics, which I think is also quite perceptive and accurate, I would just add a couple of points to that, which is not going to be news to anybody in the room, but law firms are also looking at pro bono as training, and some of them have gone a long way in formalizing pro bono programs to precisely give first and second year associates training opportunities. And so it's sort of the flip side in some ways of the clinical opportunities. And then some clinics are actually running clinics through law firm pro bono departments. And so the idea of generating sort of market responsive skills through pro bono, I think, is a paradigm shift and very different from the old clinical model. So I'll stop.
Louise.
Yeah,
Sorry,
I just,
backwards.
yeah, I just wanted to make a comment about the importance of developing the academic study of pro bono, because I think that what we've seen here is how rich it can be, and I want to commend Glee, and Fabio was part of that, but also Danielle for doing these empirical studies, because it took a long time before we did it in the US, and I think starting out early by having this empirical study is very helpful. And then I think, as Dave pointed out, it's also a way of analyzing the global and the local throughout the world, because that was so revealing to go to Europe and see this whole world developing there where there wasn't anything. In 10 years, we've had this, in really on 5 years, this great development. They just had their 9th annual European Pro Bono Forum in Spain, being planned for the fall. So it really gives us a way of globalizing or looking throughout the world about the legal profession and about legal education and so forth. So I do want to speak up for continuing to have a research dimension. And one interesting thing is, my feeling is that the law firms are interested in this. They are very interested in having it become part of the academic discourse.
So, Danielle?
Thank you. So many interesting comments and questions. Because I don't have much time, I'm going to choose only a couple. So the first one is related to big law firms versus small law firms. I would say that at least in Chile, Argentina, and Colombia, there is no tension between these two sectors of the legal profession. And I believe this is the case because the great majority of practitioners in these three countries are solo practitioners or very small law offices. They are not law firms, truly. They are not corporations, right? So they are just a few lawyers that get together. They hire an administrative assistant. They have the same office. They pay rent together, but it is not truly a law firm, right? So the big law firms in Buenos Aires, Santiago, and Bogota are politically and economically powerful, but the types of clients that they serve are very different from the ones that the majority of lawyers serve. So there's still no conflict between these two areas, these two components of the legal profession in these three countries. Now, with regard to what you were saying about the interaction between the Global North and the Global South, organizations and law firms of the North, social organizations and law firms of the South, I think that there is a very rich area of study there that hasn't been explored that much, and that I would like to call the political economy of legal knowledge. And I think that we should think more about these issues. And I think that there are two models that might be helpful to understand and to evaluate these interactions. One is what I would like to call the colonial model for the production of legal knowledge, and the other one is the free market of legal ideas model. And both models interact and determine things like the one that you were saying, that although the work that these two organizations, one from the north, one from the south, do is more or less the same in terms of quality, in terms of time and effort invested, the recognition usually goes to the global north organization or law firm. And it is problematic, right? And we have to explore why. In part of my work has been dedicated to this issue. And in one paper that Louise mentioned before, I explored this kind of interaction between legal clinics of the global north and legal clinics of the global south. In a new paper, I'm trying to make explicit these models that control the interactions not only of clinics in one region of the world and in the other one, but generally about the interactions between legal academia of the north and legal academia of the south.
Fabio.
So yeah, many issues. I'll just try to pick up two or three just to try to add something to what I've just said. But the tension between, first I want to say that this was a very, good contribution that you gave, because one thing I think both of us need to put, or whoever is doing this kind of research from, a Southern perspective, is that we have to qualify, we have to situate better, what we see as the hegemonic narrative, and acknowledge that it's problematic in the north as well. I mean, it raises tensions in the north, because we take for granted that corporate law firms and pro bono are models that have been fully assimilated in the U.S., when in fact, there's contestation here on these issues as well. So this is a very good point that we should take into account, when writing up our stuff. But well, in Brazil, as I said, there is a conflict between the two bars, but it was triggered, opposite to the states when the solo and small law firms bar saw the growth or the increasing talk on pro bono as a threat to its own interests. So it was, I don't know, I think it plays out different from what you described, but that's something we can talk about. But this is a good thing to bring up. North and South, yeah, I would say there is obviously, an asymmetrical relationship, or at least it's a complex thing, as Scott said. But again, one thing when I finished this paper, I sent out to everyone that I interviewed for, and one person replied to me saying, "Listen," and this is very good to have Daniel here, because he said, "Listen, you were mentioning the Vance Center, but let me tell you the story of Brazil. The Vance wasn't the biggest player here, because it tried to bring this model of the foundation and the law firms, and we showed them that here things would have to take place differently because of the bar opposition, and we ended up not connecting so strongly with them. So we searched for other partners in the north, and public council and other NGOs here. So there is a competition in this global world for influence too among northern organizations, and this is very intriguing too, and relates to issues of power. Finally, I just want to build on what Daniel said when he replied to our Chilean colleague about the states. I have to say that in Brazil, last year there was a constitutional amendment that made it mandatory for states to create public defenders' offices in every jurisdiction. And I was responsible for that because they used one study that I did showing the lack of coverage in public defender services to justify this constitutional amendment, which was the most influential thing that I ever did in my life. But the funny thing is, and this is why I said before, so I was in the 90s as a student leader, arguing for public defender offices. So I should be very happy, right? Well, as a scholar, I think, institutions, including public defenders' offices, that can do a lot of good things for the public, sometimes become self-serving too. And, I've seen this in Brazil. I've argued with my public defenders friends. So I think our role here is really to, study and question the workings of all these institutions, whether they're in the state or in the market or, in different parts of the profession, NGOs. That's, I guess, is the biggest contribution we can have from a scholarly or intellectual point of view.
Well, I think you could see the value and the complexity. I guess I'll just say one closing thing, which is Dave is completely right that you could see the world from the perspective of pro bono, but you can also have to see pro bono from the perspective of all the transition that's going on in the whole global market for the legal profession and legal services around the world. And all of this reminds me of another great translator, and actually, as many people here know, I've been in love with Brazil for many, many years, and it didn't even just start when I first went in 1971. It started when I first heard Sergio Mendes at Brazil 66, and they had a song that said, all the secrets of the world in a grain of sand. Look around, just look around. Let the child within you free when you look around. So let the scholar within you free when you look around and find everything in that grain of sand. This was fantastic. Thank you very much.